Hello everybody, I'm George from Ireland. Here's my English law channel. So I'm rocking a bit of stuck-up collar attitude tonight. But anyway, this is about the law of contract, particularly about the doctrine of privity. So privity is really just the old-fashioned word for privacy. But here we don't use it in the ordinary sense of privacy. It's about limitations, about rights that can be conferred by a contract, but more particularly about burdens or obligations that can be imposed on others through a contract. Those who are not parties to the contract can't have these obligations imposed upon them. But that's it in a nutshell, but I'm going to flesh it out now. It's a horrible mixed metaphor, I know. So the principle is that a contract creates rights and duties which are exchanged between parties. There are two aspects of this rule. First of all, a third party to a contract cannot gain any rights arising from the contract, although that one's attenuated. And the second part, and this is one which is clearer, stronger, is that the contract cannot impose a duty on a third party. So a third party, someone is not actually contracting. So there's a first party signs a contract with the second party. They're exchanging obligations. There's a third party who didn't sign the contract, so he or she cannot be obliged to do something or refrain from doing something because of that contract. So another thing is a third party cannot sue or indeed be sued because of this contract. So there are a number of difficulties with privity. And go back to celebrated privity case Tweddle against Atkinson in 1861. So there was a couple about to get married, and the father of the bride was a certain William Guy. So an agreement was made with the father of the bridegroom, who was Mr. Tweddle the older. So an agreement was made, there was consideration was exchanged. They're both going to give a pecuniary gift to the newlyweds. So the groom was Tweddle Jr., as in, right. So he didn't sign a contract. He didn't give any consideration. So were these contracts to be enforceable? Even though the contract actually intended for the couple who are third parties to gain benefits from it. Or there are other difficulties with it. There's a well-known case of Dunlop and Co. against Selfridge in 1915. This is about the sale of tyres. Dunlop had sold tyres onto somebody else, saying that if you sell them on again, you have to sell them at a minimum price. Well, that other party who bought the tyres from Dunlop sold them on to Selfridge, the famous London department store, but sold them at below the minimum price that was agreed. So Dunlop then took out a legal action against Selfridge and Company, that founded by that famous American chap. What was his name? Henry Gordon Selfridge. But anyway, so Dunlop had made the contract with Dew, not with Selfridge. There was a second contract between Dew and Selfridge when Mr. Dew had sold the tyres on. Therefore, no obligation was imposed on Selfridge. They couldn't be sued on the basis of it that they bought tyres for below the minimum price. So this is what the doctrine is, where a contract by its express terms purports to confer a benefit on a third party, it shall be enforceable by the third party in his own name, subject to any defences. That's how the Law Revision Committee ruled in 1937. So there are ways of getting around privity, and there are a few exceptions to the general principle. That's it with law. There are always exceptions, and then exceptions to the exceptions. So look at a tort case, for example, Donahue and Stevenson, 1932. So it was Mrs. Donahue drank the ginger beer with the snail in it, and she sued, I think it was the manufacturer rather than the person who actually sold it to her, even though she was not in a contractual relationship with Stevenson. So there's also the guarantor's right of subrogation. Look at trusts, or many people say that's not a proper exception. So this is what Lord Green, who was Master of the Rolls, ruled in very famous case Ray Shebsman in 1944. He said it is not legitimate to import into a contract the idea of a trust when the parties have given no indication that that was their intention. We come on the law of trusts in a couple of months perhaps, but trust is a very different issue, and a trust must be set up specifically, can't be created by accident. All right, other ways to circumvent the doctrine of privity. There's agency. if a third party is an agent of one of the first two parties, if there's a collateral contract, which is as in to the side of the main contract, if there's assignment going on. There are some judicial exceptions. Some people accuse the bench of activism here. There are some statutes which provide for these exceptions too. So agency is supposing the first party contracts with the second party. The second party then has a third party who is his agent. Yeah. So that's why it'll say, and my exemption from liability in particular is also passed on to my agents. So that's how some benefits can be conferred on a third party, and this way, where the contract expressly provides for it, because that would defeat the whole object of the contract if that's one or perhaps even the only purpose of the contract is to confer onto a third party. Now, confusingly, you can have more than two parties to a contract. You can have multiple parties to a contract. All right. So, but a third party means someone who's not actually signed up to this contract. Let's look at some more of these exceptions. There was Scrutton's and Midland Silicon's 1962. So in this case, someone was shipping something that was MS, and there was a carrier who was to transport the goods on. It was on barrels or something. And there was a limitation clause about liability. If we cause any damage, yes, we have to pay compensation, but up to a certain limit. And then the carrier had a contract with the stevedores. Stevedores are people who load and unload ships. The stevedores, that Scrutton's is the name of the stevedores company. But anyway, so some damage was caused, and therefore a tort action was taken out. So we had a principal contracting party, and we also had an agent. So that was the issue: is could any of these any limitation of liability be passed on through agency? I hope my battery doesn't run out. Cut out this video. Well, Lord Reed set out certain criteria pursuant to Scrutton's against Midland Silicon's 1962. He said that an agency argument would be valid if the clause made that crystal clear that it was intended to pass on this limitation of liability to a third party. So here are his criteria. First of all, the stevedore, who was a principal to the contract, must have been intended to be protected by a clause in that contract. Secondly, if the carrier was working as an agent for the stevedore being a principal of the contract when entering into a contract. Thirdly, that the carrier had the rightful authority to be an agent. And last of all, that the stevedore, who was a principal, of course, had given some compensation for the benefit conferred upon him. So more of these exceptions. The Euromedon, this case, 1974, that's the name of the ship. A lot of these are shipping cases. It was to do with this New Zealand shipping company. The shipper was transporting goods, for the carrier, and there was an exemption clause, an exemption of liability. The carrier had a collateral contract with the stevedores. Remember, those who load and unload vessels. So again, there was agency here. In this case, it's the servants, agents, and employees who were going to benefit from that exemption clause, as expressly provided for in the contract. Right, so going on, there's also Shanklin Pier and Dettel, 1951. This is yet another exception. So Shanklin Pier had a contract with some painters to paint the pier. So the painters they purchased paint from a company called Dettel. There was a collateral contract saying that the paint was going to last at least 7 years, but it didn't. Anyway, so we have building contracts. For example, if the first party assigns his rights from his contract with a third party to the second party, then that second party could sue the first sometimes. Okay, now some people said that there's been judicial activism and the judges have overstepped the bounds of the judicial role, and they have intruded into the legislative sphere as a contentious issue. Can judges make law? It's broadly agreed that they can in very limited circumstances. Look at Linden Gardens. In this case, there's a contractor who was Leinster Sludge, who formed a contract with a property owner. This is about building something, and it concluded it had the person forbidden from assigning it. So you couldn't assign rights in Linden Garden. Or there's another well-known case, which is St Martin's property and McAlpin 1994. So McAlpin was the construction company, McAlpin's Fusiliers and all that, and they had a contract with St Martin's Corporation, which owned the property. And again, it said that assignment is not allowed. So St Martin's Corporation wished to assign his rights to St Martin's Investments. Well, that didn't operate. Okay. Or look at McAlpin and Panatown 2001. McAlpin, this construction company again, they had a building contract with Panatown, and Panatown had another contract with Unex. So a duty of care deed was allowed to operate, was on the third party. Look at Jackson against Horizon Holidays 1975. Mr. Jackson, he booked a holiday for a number of his people, his family. The holiday was dreadful. It was really substandard. He was able to sue on it, and he was able to get back money for people he hadn't paid for in the family. So that was an example of privity being limited, or shall we say broken. People say the doctrine of Trinity privity hasn't been abandoned. Okay, it hasn't, but it's got holes in it. A lot of them. Admittedly, we're looking at all the holes. We're not looking at all the cases where privity is upheld and it is intact. So Jackson Wooder against Wimpey in 1980 was a case where privity was upheld more fully. So statute also introduces some exceptions to privity. For instance, the Contracts Rights of Third Parties Act 1999. So bearing in mind the overall doctrine of privity that a party cannot sue or be sued on a contract to which he isn't party. So the Act, it limits the first part of this rule. A third party can derive benefit from the contract if the contract says so clearly. That's as per section 1.1a of Contracts Rights of Third Parties Act. However, the Act can be excluded in section 1.2 if you specifically say, by the way, we're ruling out this Act operating here. There are a number of common law exceptions, agency, for example, and these are still applicable according to section 7.1. So the third party must be actually named as a group or as an individual company or person, natural person, by various descriptions. That's as per section 1.3. The party might not be extant at the time the contract is formed. It could say, or any children they may have, or anyone they later hire as a stevedore. We haven't identified this person, or any company you might later on form. Something like that doesn't exist at the time the contract's signed. Usually this third party does exist, the contract signed. I'm just saying it allows for the possibility that the third party doesn't exist at the time the contract is formed. So the third party can have the same rights as though he were, in fact, party to the contract, and that's as per section 1.5. And these third parties, they can also depend upon some of the exemption clauses in the contract, and that's as per section 1.6. So that's enough about privity. Toodaloo.